Hello and welcome to a meeting of the Consumer Debt and General Civil Subcommittee of the California Paraprofessional Program Working Group. I will take roll. Brynelson?
Present.
Fleischman?
Here.
And Hamilton is not present. Hartston?
Here.
Robinson? I think is not here. Shining?
Here.
And Judge Yu, I believe, will be joining us a little bit later. And we do have 6 members of the public. Do you want me to go ahead and call for public comment, Carolyn?
Yes, please.
So if there's any member of the public that wishes to make a comment, please raise your hand in the Zoom meeting. And I'll call on you. I don't see any raised hands.
All right. So Carolyn, if it's okay with you, I'd like to start with the wage garnishment, enforcement of judgment topic since we've got Richard here, who's spoken before. Is that okay?
Absolutely.
Did you want to start with our PowerPoint, which you graciously sent to us in advance?
I will. I'll start, but there's not much in this PowerPoint. Oh, I have the wrong PowerPoint up here. Sorry. Linda, do you have the PowerPoint handy? I'm working on 2 different computers all the time, and it makes me slow. No, I just have the wrong PowerPoint.
Are you sure it's not the one that you were reusing it because it's the same issues and we're just catching up?
No, I did make a new one.
Okay.
I found it. Oh, no, this is March 25th. This is the one I think that.
That's the one I got.
Oh, then I sent the wrong PowerPoint.
Yeah.
Okay, guys, just forgive me before you congratulate me on my PowerPoint, Carolyn. Okay, so I have it on this computer and I'm about to get it off of this computer and get it onto this other computer, and I'm gonna put it up on the screen. This is all planned so that we can give Judge Yu more time. This is,
Go with the hanging chads.
yeah. Okay. There we go. This actually has the right date and it only has 1 slide. So I tried to summarize what it is I think we need to do today. We've got follow-up items from April 19th, and then we've got a request from Amos that we talk about disclosures. So from the April 19th meeting, we have wage garnishments and their relationship to enforcement of judgment and utility shutoffs. And I tried to kind of just very briefly summarize the issue. So for wage garnishment, right, our recommendation was to exclude other than with respect to family law. And the question on the table is, does that make sense given the recommendation to include enforcement of judgments? And to help us navigate that sort of question, I invited back Richard Morrison, who you've heard from before, and I did share with you a few weeks ago his email response to my question on this topic, which I thought was fun, kind of definitive, but some of you indicated it would still be helpful to hear from him. So he's joined us. So that's why I was suggesting we start with that because he's here, then we can let him go. Then move to the utility shutoff question, and then onto disclosures. So now you have the right practice, the right PowerPoint. That is 1 slide, not emailed to you, unfortunately, but here it is. So if that makes sense, I'd suggest we start with the wage garnishment question. Does that work?
Oh, yeah, no, Mr. Morrison.
Yes.
So you see the question on the screen, Richard, and it's what I emailed to you. If you could just share your views and answer any questions that the subcommittee members have, that would be great.
Okay. Well, I would first of all say that wage garnishment is essential to enforcing judgments. I'm not sure how you can exclude that from the the list of possible remedies and be effective. But I think there is a distinction to be made between normal wage garnishments that are part of a standard civil judgment and labor commissioner judgments. Because those are really very different animals. And I think the distinctions that I had made in my comments were really related more to labor board judgments than anything else. So I'm happy to answer any questions about that. I'm not exactly sure what the intent is to, why you would want to include or exclude wage garnishments, but
Okay, so we have a few hands up. I don't know if it's just me, but I'm having some difficulty with your sound, Richard. So maybe while we let Julia ask, Julia had her hand up first. Maybe you can play around with your mic. Go ahead, Julia.
Well, first, that was the reason my hand went up. I wondered if it was just me because nobody else was saying anything. Richard, you may want to put your sound in. It sounds like almost like the insert is some falling out of where it is on your computer, but it was very rough to understand. But what I wanted to summarize was, is it then what you're saying is you cannot even imagine having wage garnishment included if it did not also include enforcement of judgment? I mean, if we have enforcement of judgment, we would have to include wage garnishment, is what I understand you to say.
what I'm trying to say is that wage garnishment is a fundamental tool, and excluding it makes no sense to me.
Okay, well, there's still an issue with your microphone, but I understood, and that then answers my question.
Okay, Stephen.
So my recollection is the reason wage garnishment was excluded is we were looking at it from the point of view of representing individual workers. And that while I agreed with Julia that it tends to be a form-driven process, which would be amenable to inclusion in the paraprofessional program, if you actually get to court and you're challenging these, the statutory schemes are incredibly complicated. And so while I thought it was a close call, my recollection is the group decided to exclude it from representing individual debtors on that basis. On the other hand, at another meeting, we decided to include enforcement of judgments in the program. And Mr. Morrison has confirmed that wage garnishment is an essential tool a paraprofessional will need to have. So given that tension and given that the first one was a close call anyway, I say we just include wage garnishments as part of enforcement of judgments and just solve the problem that way.
Okay. Carolyn?
I understand correctly that this is both creditor and debtor sides, or are you looking specifically towards representation of debtors?
Well, we were originally looking at it from the point of view of representing debtors, and that's what was excluded. My proposal is just to get rid of that and allow it, whatever we allow in connection with enforcement of judgments should include wage garnishments, period, end of story. we shouldn't do anything beyond that. So whatever we're allowing in enforcement of judgments should include wage garnishments.
That sounds reasonable to me, but I, again, do want to come back to the point that getting involved in labor commission judgments on the creditor side can be very complicated.
Well, I do hear that, Richard, and I did share your thoughts on that with the group. That has already been voted on by the full working group. So I think they could revisit it, but this particular subcommittee is not necessarily going to be able to address that issue.
All right.
Carolyn.
Okay, so this is sort of related to, I think, one of the, and did we lose Julie? This is sort of some, did we lose her?
I don't think so. I'm not sure.
I lost her photo because I really wanted to kind of bounce this off her as well. Julie, if you can hear us, Richard, where do people learn how to do this? I know I have never done wage garnishment. I have seen them and helped people respond to them, but I've never actually had to do one myself. And so my understanding is, you got to get a treatise out, or you got to work for a firm that knows how to do it, or you can't just go willy-nilly and ask an employer for some quarter of somebody's, income. There's all kinds of protections. Where do you go? How do we teach paraprofessionals to do this?
Well, I would assume that we would provide it in a curriculum whereby they would be, the way we've broken it down in licensing is that you would have to have some sort of education with respect to in-court procedure and other items that are dealing with the subject matter itself. So if it doesn't come under what is generally taught in the advocacy or court procedure, I would assume that we would have, in order for this subject matter, if it gets accepted by the body as a whole, that there would be somebody who would be teaching, or some curriculum would be invented that would go through all of the remedies involved relative to enforcement of judgment. And that would be the subject matter class that would have to be taught for this subject matter if it gets accepted by the entire group.
Okay, so bouncing off that, thank you, Julie. Bouncing off that, what do you think, Richard? How do you teach your young associates? How do we teach paralegals? And what's the difference?
Well, the mechanics of it aren't that difficult, and there are obviously some subtleties that need to be paid attention to, like service. But the big issue is what happens when the garnishee doesn't respond. How do you address that? As far as opening up an account with the sheriff and getting the sheriff to serve things, serve the notices, and so forth. That's really pretty straightforward, and I think that could be taught easily with CEB class or something.
Well, the way it's designed in at least what we've offered in the licensing subcommittee is that it's going to have to be part of their required education. It's not, at least at this point, with a vision to be outsourcing those subject matters to a CEB class. Due to restrictions in getting people who are willing to teach this subject matter, once we start going down that road of actually developing curriculum, I think we may have to, think about the people who teach CEB and whether or not that would be considered acceptable to all of us as a working group. But that's I don't think it's going to be that hard. It's just something that you have to learn to do if that's something you want to do. I mean, we've had all kinds of remedies that, debtor exams once you get your judgment. I mean, there's all kinds of stuff that you get to do.
And I would agree with that. It's not that difficult. person who, with high school education, can probably learn how to do this effectively.
Richard, it's still really hard to hear you. So I don't know if maybe try turning up your video, or if that maybe the shirt mic isn't working. Maybe if you have that, maybe you just go with your computer mic. But I see Judge Yu has joined us, and Amos, wondering if you have any thoughts or reaction to the proposal Steve put on the table to include wage garnishments as part of enforcement of judgment.
So I would support including wage garnishment as part of enforcement of judgments. I think I raised that concern before. I think the additional concern I have is if we are including wage garnishments as part of enforcement of judgments, I'm not sure why we would exclude it for representing debtors responding to wage garnishments. And I think that might have been included in Stephen's proposal. So I would be in favor of not having any exclusions related to wage garnishment. In other words, allowing paraprofessionals to handle wage garnishments from the creditor or debtor side.
Okay. Steve?
Yeah, just to clarify that, Amos, that wasn't in my proposal. My proposal was simply, we've already voted enforcement of judgments into the program. That should include, however that is phrased, that should include wage garnishments, period, end of story. We had a separate discussion about whether it should be included separately representing debtors, and that was voted down. So the answer to your question is, number one, that wasn't what I was proposing. Number two, I don't really feel that strongly about it, but I don't want to go back and create a whole new group, a whole new category for paraprofessionals to represent people in. I'm trying just to fold it into what we've already voted on, which is enforcement of judgments.
So that,
and I don't have the guidelines, I don't have the resolutions in front of me. My recollection is we decided enforcement of judgments would be limited to to limited jurisdiction court. And I don't recall if that's limited to creditors or debtors or both, but whatever it is, it is. And I'm just saying include, to avoid the inconsistency, wage garnishment can be included, and we're done.
Does that work for you, Amos?
so I was reviewing the resolutions and I don't see anything that we've voted on for wage garnishment yet. I think that might have been deferred.
It was.
So, yeah.
And enforcement of judgment. It was deferred because of this issue. The working group said, we don't want, if you're just going to come back and modify your recommendation, because we raised this issue, we may have to modify the recommendation on wage garnishment. It's like, we don't want to do that. Just wait, resolve it, and then come back to us. So yeah, go ahead.
Sorry to interrupt, but so I don't know if I agree, because I do agree that we should include wage garnishments in enforcement of judgments. What I don't know the answer to is if we do that, what that leaves as far as representing debtors when a wage garnishment is filed against them. And I don't know that the working group has voted on that yet.
That's kind of what my question was too. I mean, where are we helping people and where are we helping companies? I mean, Mr. Morrison, again, how is it your view? Have you turned away consumers because they don't have enough, a limited jurisdiction under, $15,000, $25,000, I forget. Have you turned away people because you say, oh, that's just not enough money. You really sorry. Too bad you don't have a lawyer-like thing that will assist you. Where's our market here? Is it to help people?
Well, in general terms, I can say that from the debtor side, other than a motion to vacate, there's not a lot of defense available to a judgment debtor. So, I don't know if it's worth spending a lot of time on that. If you're talking about creditor side, yeah, there are minimums that make it feasible or unfeasible to take assignment of a judgment. You know, I would not take any judgment, for example, that was less than $5,000 because, you know, even splitting the recovery on that, it's not a lot of money for potentially a significant amount of time. And if the debtor is really hard to go after, it could suck up a lot of time. And there are judgments that after trying to enforce them for a couple of years, I just reassign them back to the original judgment creditor. I don't know if that answers your question, but.
So I'm just wondering why, Amos, in your scenario, you're worried that if the limitation, if wage garnishment is allowed only vis-a-vis enforcement of judgment matters, that would exclude a situation where someone is the subject of a wage garnishment and they want to seek out a paraprofessional to help them kind of defend against it. Is that what you're worried, that scenario would be excluded?
Yeah. Yes. I don't know if it would be excluded. I just heard that in Steve's comments, and I'm just not sure where that comes from. I'm looking at the resolutions, and I just don't know what the answer would be if we decided to do a resolution allowing wage garnishments in enforcement of judgment proceedings. I don't know where that would leave representation of debtors.
Could I just say one thing though? There's a big distinction between pre-judgment debt and post-judgment debt. Whereas I think you can mount a very vigorous defense for pre-judgment debt. Post-judgment, you know, it's kind of a losing battle, and you know, as I said, other than a motion to vacate, there's just not a lot to do there.
So I don't have my notes in front of me right now, but I believe we heard some feedback about what debtors can do to respond to wage garnishments. And there were a few options and there were some timelines. And I think that was in the conversation that I think some of us are remembering about when we were voting on that. But I'm just not sure where we ended up and if there's been a final resolution. So now that we're talking about wage garnishment, I just want to make sure we're clear about what we're going to decide to include and exclude.
I'm not understanding why in enforcement of judgment representing both debtors and creditors, why that wouldn't cover your concern. Because if you're the subject of a wage garnishment, that's somebody enforcing a judgment against you, right? So
you could get paraprofessionals on both sides.
Yeah.
So I'm in agreement. I just heard from what Stephen was saying that I think he was recommending something different than that. So I just think we need to be clear.
Julia has her hand up.
I agree. I think we've spent enough time on this. I think we have Steve Fleshman now on board. I think we should just go and I don't think we have any more barriers amongst the subcommittee members. I think we should vote to clarify that we're all accepting of either side can secure a representation through paraprofessional, and that we get to enforce judgment or wage garnishment. I do not see any paraprofessional taking away work from very well-oiled machines that do this every day a week. I think this is going to primarily go to be helpful to individuals. And I just think if we're all in agreement, I have no reason to be concerned. It's time for the overall group to speak. So if we're in agreement and need to take a vote, let's do that.
Okay. I'm just
Wait, where do we stand on the issue? Where do we stand on the issue of what is the scope of enforcement of judgments? We have voted outside of this committee. We're only representing individuals. We're not representing traditional creditors, banks, collection agencies, etc. So if we're representing individuals in debt collection cases, whether creditor or debtor, I'm fine with what Julia proposed
So
Okay,
can
in
I,
limited jurisdiction court.
can I read the resolutions from the last meeting? What was adopted was legal paraprofessionals may represent individual debtors in consumer debt proceedings. So consumer debt proceedings, it was limited to individual debtor, representation of individual debtors. The enforcement of judgment recommendation resolution that did not get voted on was paraprofessionals may represent natural persons in enforcement of small claims court judgments and natural person debtors in limited jurisdiction post-judgment enforcement proceedings. So that's what we put forward at the last meeting.
can you put that resolution up, Leah? Is that,
I can, it's not on my screen, it's on this computer, but I can. And then I need to run and answer my door. So let me do that.
We can all talk amongst ourselves.
Yeah. So here are the resolutions. So yeah, here they are, and I'm going to run and answer my door.
Okay. Okay, so while everybody's reading that, I'll just continue my minority opinion. We're all very, very intelligent folks here. We're everyone was selected here, because they understood the things that consumers need. And I got to tell you, I barely understand how to do this myself. I've done it. I've done post-judgment enforcement as someone who gets verdicts and awards and judgments. I do that, and I do it with great care. And the notice requirements are not simple and must be respected. And I'm no judge. I'm sure many judges have taken me to task to make sure I've made many trips back to the courthouse to make sure I perfect that notice. So I just don't, with all due respect, and maybe, respond to me, Richard, or Steve. Yes, filling out the forms for the wage garnishment can be easy, maybe. But this is hard for us to articulate in a resolution. How are we going to teach this to people who haven't had contract law, who haven't had a course? There's no course in law school on judgments. There's no course in law school on this.
well, there is a course on contracts, Carolyn, and there's one that's required in an ABA approved program for paralegals. So contract law is required in law school, and it's required in paralegal programs.
Okay.
So, they're going to have to test out of these requirements. And if they can't, then that's what they're going to have to do, is go to law school or go to a paralegal school and take a contracts law class. So, that's why we made it stringent for the eligibility requirements. So folks are not going to be coming, with nothing. If they don't have, a paralegal certificate, they're going to have to go get one.
Amos, now that these resolutions are up, it's very helpful. What I had envisioned, Amos, is deleting the third resolution about wage garnishment and clarifying that wage garnishment is included in the first and the last.
So I agree with deleting that. I think my concern is in the final proposed resolution that has not yet been voted on, that legal paraprofessionals may represent natural persons in enforcement of small claims court judgments and natural person debtors in limited jurisdiction post judgments. That means, I think, for wage garnishments, with respect to wage garnishments particularly, either the creditor or debtor could hire somebody to help with wage garnishments in a small claims court judgment, but not for a limited jurisdiction. Only the debtor would be able to do it. So if the intent is to allow paraprofessionals to enforce judgments using wage garnishments when they're enforcing limited jurisdiction, we would have to, I think, revise that proposal.
Then we just say natural persons, plural, and strike the word debtors.
Then I
Excuse me,
think that covers it.
Which one are we talking about, Amos?
Right
The last one.
where my,
Okay,
you would, not debtors, you would strike, not person, you would strike debtors.
And it would be natural persons, plural.
yes.
Okay.
I'm
And
gonna-
then if anyone feels it's necessary, we would clarify that the first resolution and the last resolution as modified includes wage garnishment. I don't believe that is necessary because we're just including the subject matter and we don't need to say what's included in the subject matter. We only need to exclude what we're excluding, for example, in the first two.
Yeah, and I think it was very important to Stephen to make sure, Hamilton that is, that it said except in family law practice areas. So we have to keep that clear.
We wouldn't need that anymore, right? Because there's no exclusion. We're not even talking about wage garnishment as under Steve's proposal.
Yeah, so my understanding is by statute, and I'll try to look it up, family law is not limited jurisdiction, it's unlimited jurisdiction. So it wouldn't fall into this last resolution. I'm looking it up now.
I'm pretty sure you're right, Steve. It's categorized unlimited because of the level of judges that you have, and we don't have municipal. I think they're all categorized, and Judge Yu again she will.
If I may, I could address Carolyn's concerns a little bit. Judgment enforcement has a lot of boxes that need to be checked off in the process. There are a lot of hoops to jump through. They really need to be paid attention to, like was the debtor served personally, and that sort of thing. But there's not a lot of independent judgment or decision making involved in the process. So I think it's fairly amenable to someone who gets legal information and it doesn't really require a lot of legal advice. I mean, that's my interpretation. I don't find it, it's not like I'm playing a lawyer when I go in front of a judge. These are things I have to provide for the judge. I need to know in advance what those are, but it's not that difficult, and there's not necessarily a lot of arguing about finer points.
Well, but again, what if you get the wrong entity? What if you get the wrong person? What if you miss a person that you should have found through an investigator? What if you you give them subservice incorrectly, or you have to mail serve them incorrectly? What if you take their house? There's a lot of things that seem to me to be things that you could screw up very easily on both sides. Don't you?
It's limited jurisdiction.
My hand up.
Yeah, Judge Yu's had her
You
hand.
could still,
I
could
agree
still
with
put a
what
lien on a house.
Kristen said, and I think a lot of things that Carolyn is raising are factual issues, again, not legal issues like Mr. Morrison said, and the judge will ask questions, and those things do kind of get messed up when people are not represented. But if you had a paraprofessional who has done this and who has had to look these things up, it would just be so much more efficient for the court to have litigants have a paraprofessional or someone who could understand that these things need to be done and questions need to be answered. So I'm in favor of what we've been discussing and moving toward. Thank you. I'll lower my hand.
Does that mean, Judge Yu, you're in favor of the revised resolution striking the limitation to debtors in the last resolved?
Yes,
Okay,
because like Steve said, we already made it clear it's not going to, like banking institutions wouldn't be the anticipated client or even allowed client.
okay. Steve, is that a new hand?
No, it isn't.
All right. So do you, Carolyn, want to take a vote? It sounds like our solution or what we're contemplating is not bringing forward a separate resolution on wage garnishments. Instead, amending the last resolution on the screen to strike the word debtors, change person to persons, and make it clear in the text of the memo that we contemplate wage garnishments is a tool that will be used in enforcement of judgment work.
Yeah, let's do it. I think I've said my piece.
You want to take a vote, or I don't, you don't have to.
No. I think we're ready. I mean, I think I've got my minority report in there. I might modify it a little bit, but I definitely don't want to rehash the world that's already been decided.
Could Leah or Linda put a proposed that resolution on so we can vote on it?
You want to vote? I'm saying we don't have to, but you can. We can. I can't. This is a PDF document, so I cannot.
All right, that's fine. I move to adopt the proposal as outlined by Leah.
I second that proposal.
I think Leah is even wondering if Carolyn is asking for a vote, since it seems to be that there's consensus. But if we do need to have a vote, I'm happy to cast a vote.
Yeah, I think we need to, because I'm gonna
Okay.
vote it a different way.
Okay. So Linda, can you take the roll?
Yes, and I just want to be clear, so that was moved by Fleischman and second by Brynildson.
Yes,
Okay, Brynildson,
adopt the change.
yes?
Yes,
Fleischman,
Yes.
I think Stephen Hamilton is still not here. Hardston,
Yes.
I don't think Nicole is here either. Shining,
I guess I'll abstain because I'm confused.
okay. And Judge Yu,
Yes. Thank you.
the motion carries.
Right. Thank you, Richard.
Yes. Thank you, Mr. Morrison.
Yes.
Coming.
Thank you.
All right.
thank you.
Leah, I think we're going to need that PDF to address utility shut off also.
You think so? Okay. Then let me put it back.
So what my recollection, what happened on utility shut off is that we as a subcommittee thought, since it's almost always less than $500 in dispute, sort of what's the point of hiring a paraprofessional, and, are we doing more harm than good? When that went to the full committee, there was skepticism of that rationale, because if you look at the second resolution, paraprofessionals will be allowed to represent people in connection with settlements of debt claims. So, this is one I don't feel strongly about one way or another, but my view is if we simply eliminate the fourth resolution, we're done, because the second resolution would include utility shutoffs.
So, sorry, Steve, I think because it's small, or I'm not sure exactly if it's there. When you said second and the fourth, I really wasn't sure exactly what statements you were referring to.
Okay, so creditor harassment is included. What's included is pre-litigation cease and desist and prove-up letters and pre-litigation negotiation of settlements, including payment plans. So I believe it was Dana brought up, if we're allowing paraprofessionals to do that, why is a shut-off letter from a utility company any different than a run-of-the-mill, than any other type of creditor? And why shouldn't a paraprofessional be allowed to help and work out a payment plan to avoid utilities being shut off? And with that point, I'm totally fine with that. I have no problem with that. I'm skeptical about the economics, but if market forces are going to dictate, then in my opinion, all we need to do is eliminate the fourth resolution that utility shut off is excluded from the program.
My question is creditor harassment a term of art? Because does every utility shut off circumstance necessarily involve a creditor harassment situation? That's because I think what you're saying makes sense if it always is creditor harassment. But if it's not always creditor harassment, like for example, I'm not harassing you as your creditor, I'm just letting you know that I'm shutting off your water. That would be my only concern that we would.
I don't care how creditor harassment is defined in the resolved sentence, because however it's defined, what I'm comfortable with is included. So whether something is, look, every creditor thinks they're owed money, every debtor thinks they don't owe money. Whether it's harassment or not, it's sort of beside the point. We're going to allow paraprofessionals to write cease and desist improve-up letters and negotiate settlements, including payment plans. Whether it rises to the level of harassment, to me, doesn't matter. Does that address your concern, Leah?
I see Leah's point because, well, since the Court of Appeal has done that and cited Google, I'll admit that I just Googled what is creditor harassment, because people are going to look at what we write and look to see what the common meaning is. And it doesn't include utility shutoff. So I'm afraid if we say creditor harassment, including utility shutoff, then we're maybe excluding other things. So maybe we need a different term, because creditor harassment does seem to be a term of art, which is where the person is actually receiving repeated phone calls, repeated contacts, things that are actually illegal, like contacting people's relatives and all that kind of stuff. That seems
Erica,
to be what creditor harassment means.
Would you be comfortable adding a third bullet point under included to include negotiation of non-payment of utility services?
Yes, but do you think that might just in the inclusion lead people to believe that other things are excluded? We're a little bit stuck, and I'm happy to do it that way if we think that there's no danger of other things maybe being excluded that we don't intend to exclude.
I think the average California consumer would not draw a distinction. They just think somebody's telling me I owe them money, and who that person is matters less than I owe the money, I don't owe the money, I don't have the money, I need to work out a payment plan. So while I understand what you're saying from a drafting perspective, I personally don't think it matters here, and I'm fine including that third bullet point, which we can work on.
Julia, and then I have a comment.
So I guess what I was thinking was, I know this, maybe I'm hearing it differently than it's sounding to me. Do we have to use the term creditor harassment? Can we just not say creditor claims, creditor enforcement of debt, or something along a more generic term, that it's not just about the phone calls, it's not just about the harassing in quotation marks, it's what can this person be equipped to do on behalf of a debtor to make the creditor situation go away, is what I'm hearing.
The problem is, if you water it down that way, then it all sort of falls apart because of the last resolution. Because you can represent individuals in limited jurisdiction court. This creditor harassment was the tangled web of numerous state and federal statutes, which we decided to exclude. And I'm reluctant to go away from creditor harassment. If what I'm hearing is we would rather just rewrite the fourth resolution to be included rather than excluded.
Okay. Okay. So
Oh,
I just,
Carolyn, Amos's hand has been up.
Okay.
Sorry.
So I think this might be Julia's point. So I'm not sure if it addresses what you just said, Stephen, but one fix might be for the second resolution that's up on the screen, which has already been voted on. So we'd have to revise that. Instead of saying resolve that the following creditor harassment activities, I think we could say resolved that the following debt collection and creditor harassment activities be included, excluded. And that would mean that the included bullet points would relate to debt collection or creditor harassment, as well as the exclusion. So I guess my proposal would be instead of creditor harassment there, could say debt collection and creditor harassment.
Thank you, Amos.
What about just fixing the fourth resolution to say included?
That's what I'm feeling like would be cleaner.
So I think the issue would be, what if a retail store, let's say Walmart, is collecting on a debt? That's not creditor harassment. So creditor harassment is a defined term, or I should say that there are statutes, both state and federal statutes, that give debtors protections, like the number of harassing phone calls or letters or certain kinds of threats. That would be within the term creditor harassment. So I think the issue is, are we intending to include or intending to exclude where there's not technically violation of statutes, but there is debt collection?
And I was hoping to include it.
Right, and I think the resolution, the second resolution on the screen, says that included will be pre-litigation negotiation and cease and desist letters, and excluding litigation, which I think is what we would intend, both with respect to creditor harassment and general debt collection.
Well, and I think the first resolution indicates that we are talking about consumer debt, but because that language is not included in the second one, it looks like we're not including consumer debt with credit harassment. It's very specific to credit harassment. And I think what you suggested, Amos, would take care of my concerns.
okay. Let me jump in and apologize in advance. I am pining for the way Utah defines this. And I would just urge everybody to go and see because creditor debt is one of the debt collection matters is one of the Utah topics. And rule 14-802 describes this. It says, it's very simple. It's only small claims though. And it's counseling and advice and settlement agreements, and then explaining to the client a court order. And it's one thing. And so I'm pining for Utah here. And I know Arizona is even more simple. I don't like Arizona because it's too simple. And not sure I would agree with Utah and everything either, but I wish I had urged everybody to look at this beforehand, but it's getting so complicated that it's beyond confusing. And okay, so that's point number one. Point number two is California Civil Code 6560. A person means natural person. Okay, forget it. I'm reading it wrong. Anyway, look at the Utah provision. It's so simple and clean. If we have to do this, and I'm saying this is so complicated, couldn't possibly vote for it because nobody here understands what it says, and you're all trying to clarify it. Again, you're all very smart people. Everybody here is extremely bright. And You're trying to clarify it in a way that makes it more complicated.
Well,
Yeah, I'm reluctant to touch a resolution that's been voted on by the full group. And so while I understand what Julia and Amos are saying about trying to fix the second one, I'd rather just fix the fourth one, which wasn't voted on. And I think substantively, we're all saying the same thing.
Well, when somebody goes, the problem with the utility payment is it's really easy. They don't have to harass you. They turn your water off. Okay. You can't pay it. You need water. You move to another apartment and you try and get the water back on. And they say, we're really sorry. We're not putting the water back on. So you have it put in the name of somebody. And 2 months into the payment plan that they try and set up because you're low income, your credit is ruined. So this isn't something where it's creditor harassment. It's something that people really want. This is something that was very high up, I think, on the, and Leah, correct me if I'm wrong, this was very high up on the study, the 2019 study, that people need help here. I know we're at our wit's end and we're at our time has run out, but it's just frustrating that we're trying to shoehorn something that really people wanted in there, but they turn your water off. It's really simple.
So I think we have two options. The simplest option is to modify the one to, I think it's the third resolution, to say that wage garnishment is included. Not, oh, sorry, not wage, sorry, let me confuse some more. Fourth resolution to say utility shutoffs are included. That's simple. It's narrowly tailored to address the specific issue that came out of the April 19th meeting. What I think Amos and some others are raising is, well, we don't want this kind of activity to necessarily be limited just to the utility context. This pre-judgment sort of negotiation kind of work that somebody might do with a creditor, we'd like the paraprofessional to be able to assist in, even if it's not harassment and even if it's not a utility company. So that would speak to broadening, modifying the second resolved. And I wonder if, so it could be that we bring forward two different recommendations to the working group and they decide what they want to do. Or if you all could be comfortable with a modification to the second resolve that referred specifically to pre-judgment kind of activity, because this is that stuff Richard Morrison was talking about, all the negotiation type of stuff to help people deal with creditors.
so what I'm hearing you say, Leah, is that technically, you know, we could take care of both problems by doing the modification that Amos proposes. So is there any way we can just vote on making that one recommendation that we modify this? We propose to the whole group that if we're in agreement as a subcommittee, that we agree that we would like to make those two modifications to the previously voted on resolution?
You could. I would just suggest we might want to say pre-judgment debt collection and creditor harassment activities, because otherwise it does get confusing when you look at it vis-a-vis the last resolution. We're making a distinction that this pre-judgment work is allowed. And
Well,
then,
it says specifically in the included part, pre-litigation.
yeah, I know. I was thinking though it could be it also in the title of the resolved to make it really clean. But so I could pull this down and try to put something up, but I do think the kind of threshold question is, is there a desire to vote on a modified resolution 2, second resolution, or just to stick with working with resolution 4?
I want to just fix 4.
So I'll just note, sorry, hands up. Go ahead, Judge Yu.
Oh, sorry, Amos, but thanks. I know it's hard to work on something that maybe we already did, but sometimes I think it's better to just take a step back and deconstruct it and reconstruct it if it's going to be better than try to work with something that maybe isn't really quite right. That's all I wanted to say. Thank you, Amos.
A couple more people have their hands up. Carolyn, maybe if you could calm folks, I'm going to try to bring a Word document up so maybe we can play with the results.
Okay, Amos, you're next.
Thank you. So I was just going to say, if we do fix that other resolution, I don't think we need the fourth resolution anymore at all.
No.
Julie, did you have something to say?
No, I think that's the most efficient way if the subcommittee is in agreement. I think we're interested in proposing either amendments or, as Judge Yu suggested, redrafting it and proposing it to the whole group, but to accomplish the two things of clarifying what we would like to do with 4 and include the additional language that would include activities pre-litigation beyond just creditor harassment, but to include pre-litigation consumer debt collection, as stated by Amos.
Of individuals. Individual debtors,
Natural persons.
natural person debtors.
I thought we were saying we were doing both, as long as they're natural persons.
No, we're not. Oh. In limited jurisdiction, yes. This may or may not be limited jurisdiction.
So this is Amos's change, right? This is the only change. Is that right? There's no change into these bullets.
Correct.
So just the inclusion of consumer debt.
I think somewhere we need natural persons.
Okay.
So I can say the consumer debt and creditor harassment activities,
On behalf of.
On behalf of individual persons.
natural persons.
Yeah.
Okay. So those are the modifications from the resolution that has already gone forward. And then this would encompass the utility shutoff.
Can you please include the exclusion from the other resolution?
Mhm.
Yes, I agree.
Sorry, can I just ask a question for the on behalf of natural persons? I think the other resolution said represent individual debtors in limited jurisdiction. Is the intent here to be natural persons or natural person debtors?
I want natural person debtors. Julia objected.
Well, I think that if we say natural persons, I'm sorry, Julie, if I'm jumping in, then there are creditors who might need to have paraprofessional support as well. So I support what Julia was saying, that it should just be natural persons.
I support that as well.
Okay.
I don't think that there's any harm in including it, simply because in my experience representing businesses, they're going to have somebody more sophisticated. They're not going to be using a paraprofessional. They're going to have somebody that works with them regularly. So I'm not feeling that there's any risk of doing something like this.
Okay. Do you want to take a vote on this one, Carolyn?
May as well.
Okay.
So I will make a motion to, and I think the way we should word this is to have this resolution replace the one that was previously passed. And that we don't put the fourth resolution related to excluding, I don't have it in front of me, but the fourth resolution that we're talking about, this, I think this replaces that.
And Linda, I think it's motion to replace, not to have motion. Okay, yeah.
That's Leah typing, by the way.
Oh, thank you.
So sorry if that motion wasn't clear. So the motion is to have the below replace the previously passed motion regarding credit harassment and eliminate the previously submitted motion regarding utility slot. Exactly. Thank you.
Okay, so Amos has made the motion. Do we have a second?
I have a second.
Ready to vote? Should I call it? Okay. Brennelson,
Yes.
Fleischman,
Yes.
I think Hamilton is still absent. Hardston,
Yes.
Robinson is absent. Shining,
No.
and Judge Yu,
Yes, thanks, Linda.
the motion carries.
So for our last item, I do want to bring back up the PowerPoint. And maybe Amos, you want to introduce this topic? And I just put up some things from your email as well as the turn issue, because I thought that was relevant for disclosures also.
Great. So separately in the regulations subcommittee, we are on the topic of mandatory disclosures before representation by a paraprofessional and what should be included in those mandatory disclosures. I think there's general things that we're including, like not an attorney and some other things, but it seems to me there might be some practice area specific disclosures that may be required. So it's clear what a paraprofessional can and can't do, particularly where there's some risks. So for consumer debt and general civil, for example, I think there was extended discussion about federal claims and federal court not being available. I think the way this is set up, there is defense of debtors claims, but there can't be affirmative defenses or counterclaims of harassment. So those are the types of things. We haven't figured all this out, and the regulation subcommittee hasn't been participating in all these meetings. So I thought it might be something for each subcommittee to think about. What are the appropriate disclosures and what are the risks of hiring a paraprofessional in this practice group? So I just wanted to tee that up for consideration because I don't know if the regulation subcommittee can do it on its own.
I have a hand up.
Oh, Judge Yu, yes, of course.
Thank you so much, Carolyn. So I have three questions, I guess. And if I could just say them so I don't forget them, Amos, sorry. The first is, do we want to revisit the inability to bring counterclaims related to creditor harassment? And these are just, the other two are general. Is there going to be a disclosure required of paraprofessionals to direct potential clients to free legal services in other areas like turn? And then is there going to be a disclosure for paraprofessionals to direct potential clients to services that can provide actual language assistance? So if the paraprofessional doesn't speak the person's language, that the client could be directed to agencies that, like legal service agencies that do speak the person's language?
So I will hold on the first question about whether we're going to revisit that and just talk about the disclosures. I have proposed meaningful disclosures that would allow a consumer to make an informed choice, including alternative services available, but it appears to be controversial. So I actually don't know what's going to be included in the final recommendation. There certainly will be some disclosures
Okay.
about a limited license, but I don't know how specific it's going to be. And one concern that was raised is there's a lot of different jurisdictions, a lot of different services, how it would be difficult, potentially difficult to place the burden on paraprofessionals to, provide detailed information. So maybe there might be a solution of some standardized forms or maybe a website link or something like that. But I don't think we've reached an agreement. What I'm focused on, right, so that's generally, what I'm focused on now is specific risks in specific practice areas, because I don't think it'll be included at all if it's up to the regulation subcommittee, because the regulation subcommittee doesn't know those answers.
So just as an aside, thank you, Amos, for answering those last two questions. The California Access to Justice Commission, which we are on, I mean, there are entities that sort of can list the various agencies in different jurisdictions. So I really don't think it would be that hard, but that's just an aside.
Can I respond to that? So I actually think that's a great solution. And I think it was suggested maybe by Justice Patru, but either the bar or the Access Commission or some entity could compile this. And then the mandatory disclosure could be the link or something like that. I think that's a great solution. But right now, we don't have that resource that I think is fulsome. And I think there's some resistance to putting too much burden on the paraprofessionals, which makes sense. Yeah. So I think we're going to have to come up with some middle ground. But with respect to practice areas in particular, I think we may need to, we need to identify what the risks are if we're going to make them mandatory disclosures.
Okay, thanks.
So, Julia, do you want to go first?
Yeah, I was thinking this as they were talking, if this is something that's going to be governed by the state bar, why not make the link going to a place on the state bar that would require someone hiring a paraprofessional? I mean, if there's some way that they can show that they have navigated to it and have viewed the disclosures. I mean, these days, all you need is a phone to be able to do that. And therefore, the state bar could house what the disclosures are that they are provided each and every time. And I don't know about how to create that, but I would think that that could be created in a way that if since we're going to be tracking their clients or however we're going to do that in order to regulate them, perhaps we could see, are they each and every time requiring their new client to go to the disclosures? You can lead a horse to water, but you can't make them drink. So whether they read them, I don't know. But at least we could do that as a proposal.
So I think that makes perfect sense. In my mind, I think there's two different types of disclosures, and I might be making this distinction myself, but it's alternatives. So that would be like free legal services that might be available, or free consultation with an attorney, or limited scope services, or alternatives. And then risks, because of the limited license. In other words, if you hire a paraprofessional, paraprofessional cannot represent you at trial. So if your case goes to trial, you may need to represent yourself or hire an attorney or something like that. So, again, I think in my mind, or at least how the discussions have been for alternatives. So, what legal services are available? It might be hard to require paraprofessionals to provide specific information, certainly whether they qualify or if they're available. But there might be a resource that we can link to or create and link to that link is provided for specific risks in a specific practice area. Wherever it's housed, we don't know what that's going to say.
I like your two ideas. I'll just throw that in. I like the two ways, the concerns you have, and that's a good idea.
Okay. So, all right. I have a lot of thoughts on this, but I will try and keep it brief and to the most important ones. I think I'm in favor of these. And when you talk about, I'd like to see, again, I'm going to try and sit in on the regulation one. I have to drive to Fresno for an in-person deposition during the regulation subcommittee meeting. But I'd really want to see, this is one of these cases again, I don't know how I can vote on it without seeing what you guys are doing. litigate federal claims, there's two other things I think you would have to mention, which is class actions. I think you have to be able to tell people that the paraprofessional is not going to be able to bring a consumer class action. And also, I think you should mention the Fair Debt Collection statutes, the biggies, the at least Fair Debt Collection, because I think that comes with penalties, per enforcement, per activity. So I think, Amos, if you could mention a couple of those big ones, because if you don't understand that in that, whatever it is unfair, Abbas was here and he's the expert in that. And he was telling us there are many times where people come in and they missed a thing in the mortgage sale contract or the lemon law, there's many things where people are going to miss that. So if you could pick the biggies in the inability to litigate, the other thing you could do is you could maybe in our regulations or the ultimate legislation, like we do in, in our settlements and releases, there's language we have to quote and some statutes that we have to abide by. Make these settlements include not a waiver, but a inclusion of rights should someone post-settlement discover that there is a class action that covers them. So maybe in our statute, this isn't necessarily in the warning, but you could say in the statute, you can settle this paraprofessional. And if it comes out later that there was a class action that would have given you something, that settlement is unenforceable. So maybe that it just sprung to my mind. So yeah, those are the two. I mean, we can go back and on and on and on. Yeah, about the 1,000. There was that website that someone said again in our meetings that had the medical providers, that said, here are the medical health plan things that you can turn to, but nobody had heard of it. I hadn't heard of it. And you could get overwhelmed with that. I think a website is just going to get lost in the shuffle. So I think that's I don't know that like you, I don't have a solution to where you put some of that information, but yeah, class actions, letting people know about some of the broader, bigger statutes that get in and just say, paraprofessional is not going to be able to enforce for you a fair act, some kind of $1,000 a hit. I mean, maybe they could. Again, you're actually the expert in this, so I'd like to kind of hear and think through which of those statutes, when you say federal claims, are the big ones that we have to say to people. $1,000 a phone call after 8 p.m. Class action where you might be able to get, this whole thing wiped away and $400.
Amos, is it all right? I'm not being recognized, but I have my hand up, Carolyn. So I just wanted to know if we should revisit the inability to bring counterclaims, because I don't recall why we said that they would not be able to do that. If they're, representing someone who is being harassed, and they identify that, I mean, or they're asked to, somebody's feeling harassed and they're like, please help me, I'm being harassed. They can't then make a counterclaim for being harassed?
Your Honor, it was a federal counterclaim that would bring the case up into federal court.
Okay, so can we bring a federal counterclaim?
So
They do it in limited jurisdiction in a state court. Can we just let them do that?
So I will say that I think this is one of the biggest loopholes in what we've done. And that's one of the reasons why I think this needs to be disclosed if we, with the current state. So as I understand it, paraprofessional will be able to represent debtors in litigation against, creditors seeking to enforce a debt, but they will not be able to bring counterclaims, state or federal counterclaims. And there are both state and federal protections for debtors. I think that needs to be disclosed or we need to fix it because I think that is a pretty big limitation. My experience is that the state counterclaims are very good and the state law is very good and they don't need to be necessarily federal counterclaims to be effective. Federal counterclaims can be brought in state court and no reason why a paraprofessional couldn't litigate that if we allowed them to. But of course, we can't control, practice in federal court. So either, I think, my view is we either revisit this and try to close that large gap, or we make very clear disclosures. And I don't know that it's a clear disclosure to cite to a statute. I think, it should be made clear what the paraprofessional can and can't do. And again, I don't think that's going to come out of the regulation subcommittee. If there's particular risks in the consumer debt or general civil practice area, I think this committee would need to identify them.
Oh, Judge, you again.
Okay, and Steve has had, but I have a quick sort of adjustment to my question. So Amos, if someone were able to represent a client as a paraprofessional in state court in limited jurisdiction, would that be sufficient for the state provided counterclaims?
Yeah, except our resolution specifically excluded litigating creditor harassment claims.
Yes, yeah, but
So it's not so much. I think the practice is, if an attorney represented a debtor, they would be looking for potential counterclaims, and that's a significant part of the representation of debtors, is looking both for leverage and obviously if there's legitimate claims to be able to allege counterclaims. But my understanding of our resolutions is we've just not allowed it.
I know, but I'm just trying to, it helps me analyze whether it should be even addressed to determine if a paraprofessional were able to bring such a state counterclaim. Would the limited jurisdiction cap be sufficient, or is it something where they'd have to do it in superior court or unlimited, and maybe we should just not go there?
Oh, got it. Yeah, no, there's no reason why a claim under the Consumer Protection for Debtors can't be made in limited jurisdiction court.
That's a sufficient dollar amount that would get them their whatever statutory protections there are in state.
You're right. There are some protections they might not be eligible for, like attorney's fees. I think that would require potentially statutory amendments. But as far as asserting a claim on behalf of the debtor, I think that could be done in limited jurisdiction court.
Okay, thanks.
Oh, Steve.
Yeah, Erica, we spent a great deal of time on this issue, and the federal statutes and the state statutes are incredibly complicated and incredibly interrelated. And there was a sense, I believe, Leah can go back and look, I thought it was unanimous, maybe I'm wrong, maybe Ira dissented, that this was beyond the scope of what we thought a paraprofessional could do, number one. Number two, the real leverage in these cases is the threat of the class action, which is off the table. And number three, what we heard from practitioners is the best way to deal with these issues is to take the offense and file the action first in federal court, or if you file in state court, it's going to get removed to federal court. And that had we allowed paraprofessionals to do that, there would be situations where they filed and the case got removed and they'd be at a disadvantage. So you're giving up your best weapon if you wait to be sued and then you counterclaim, even though that couldn't be removed. And it was just creating a sort of two-tiered sort of justice system. And we decided against it with the understanding that, like in Washington, if this issue comes up, that the paraprofessional can refer the matter to an attorney for no referral fee. And so, if someone has a legitimate claim under one of these acts, the paraprofessional can refer them to somebody. But, more precisely, I'm really not in favor of revisiting things that have already been decided.
Steve, I have, oh, sorry, were you finished?
Yeah, go ahead.
Okay, Steve, throughout this process, I keep getting reminded of how much respect I have for you and what an extraordinary memory you have. I mean, you remember so many things in great detail, and I wish I could do that. I'm so impressed with you, Steve. Um,
Thank you.
You know, I don't remember all of the details, but I do remember I did vote for this. You know, I voted that they shouldn't be able to bring the counterclaim, but I have since then learned more and heard more. So I'm thinking about it again. I agree we shouldn't go into a whole full discussion, but I'm just sort of wanting to think it through one more time, because what I'm wondering about is, let's say there's just this person who bought a used car and the car is a lemon, and you know they don't want to pay on it anymore because they can't afford it and the car's not working, and now the card, because this is going back to my story where I represented the Jesus Loves You, I mean we represented the consumer who was being sued by the Jesus Loves You used car dealership, and that was their name. And so now they're being harassed, and they basically they don't care if they have a class action. They just want to be able to assert that they're being harassed is a defense to not paying on the car.
Well, you know, in the context of cars, you should speak to your colleague Socrates Manukian. You know, there is absolutely no shortage of attorneys bringing lemon law lawsuits in California, and my firm defends a fair amount of those on appeal. It is a vibrant area of practice, and I would really urge you to ask him if he thinks there's a shortage in that area. Okay, so there's that. And you know, as to the person that's being harassed, we're including that in the program for pre-litigation. And if there's a claim there, then the paraprofessional just refers them, just like in Washington. Nobody's going to go without representation. And from what I understood from a boss, he'll take any one of those cases for $800. And if there's actually a real claim there, he'll probably waive the $800 because he's going to collect attorney's fees on it. So I think we're chasing our tail for a problem that at least hasn't been documented to exist.
But what if we,
Sorry, Carolyn.
what if we,
the car? Oh, sorry, Carolyn.
well, just to kind of a cut in and maybe get it moving here a little bit, because I hear both of you. And I respect Steve's ability to remember these things too.
It's extraordinary.
I'm my mind is spinning at this point in time. But what if we, because we have spent a lot of time on this, but we should be able to revisit it. This could be brought up again at the bigger meeting. It could be that Amos could bring us back something to sort of tweak this from his group. It is, there's no way to probably find that that resolution somewhere. So I don't, what we're talking now is about the way we warn people about these things, I think. And so if we've decided this as a group, we decided it. And how do we describe what it is? Again, there's so many complexities. So how do we tell people? We tell them at some point your paraprofessional may need to, when it's filed, ding, 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 get you an attorney. And that's going to be on them. There's $100,000 bond, I gather, you know, if they screw it up and they don't refer you when they should have.
So
Fee or not.
sorry to interrupt, but actually the disclosures I am referring to are pre-representation. So this is not, if it comes up, there are separate, you know, rules of professional conduct that happen if something comes up during representation and what disclosures. But what I'm talking about is the regulation subcommittee is considering what pre-engagement disclosures. So prior to entering into a written contract for legal services, some disclosures need to be made. And I'm just teeing it up for this committee. Are there any specific disclosures about risks of hiring a paraprofessional that should be made with respect to the consumer debt and general civil practice? I'm just teeing up that we have discussed federal claims. You're right, class actions, but I think this inability to bring counterclaims related to creditor harassment might be a large one too.
I'm totally fine with all those disclosures. I'm assuming they're going to go in the retainer agreement.
That's also
Don't make
added to.
assumptions.
Sorry.
These are hot topics over in the regulation subcommittee.
Yeah, either in a separate writing or within the retention agreement, one or the other. But again, I don't think there'll be any of these disclosures specific unless we as a subcommittee identify them and suggest them.
Yeah, and it sounds, Amos, like in addition to what we have in this PowerPoint is Carolyn's suggestion that some of the major federal statutes, like we further clarified federal claims and sort of the potential monetary awards that go with those claims. Did you want to say something, Julia?
So what we're talking about then is pre-retainer disclosures. And then we also talked about disclosures when the paraprofessional is retained, right? Wasn't that the first subject, or was this all along, Amos, a discussion of what disclosures they should receive even prior to retaining this paraprofessional?
Yeah, so that's the issue that the regulation subcommittee is currently discussing, is the pre-retention. I don't think there's going to be a specific rule about disclosures during, because there are rules of professional conduct that track what applies to attorneys, keeping the client informed. If it does go beyond the limited license, there'll need to be a discussion and a referral, but not specific disclosures that we are talking about. This is really with respect to pre-engagement.
Okay, so I guess my question then is, it is going to be hard to encapsulate each factual scenario that may arise. So I'm all for having disclosures prior to them retaining paraprofessionals. I just don't know, without really doing, the regulation committee, I think, is going to have to really do the work on that. It's I don't know how you do it. It's going to take some time and some thought, but I agree it should be done.
So my point is, and the reason why I'm raising it here, I don't think the regulation subcommittee is going to be able to go through each practice area and determine what the risks are that need to be disclosed. I think there are going to be some general mandatory disclosures, like the paraprofessional is not an attorney, they have a limited license, that sort of thing. But unless the practice areas identify specific risks that should be disclosed, I just don't, my estimation is they won't be included.
So then what you're really asking us is what disclosures for us as a subject matter would we want with respect to this subject matter, and recommend those to the group because your other subcommittee is not going to do this for us?
If any. So I don't want to assume that there are necessary disclosures. I'm just saying that if there are practice area specific disclosures, I'm teeing it up that maybe this is the right group to consider that, because I don't know that the regulation subcommittee would be able to do that.
Then I agree that with what Leah said, that we should kind of explain what federal claims means, because a layperson may not know what that means, including what the remedies might be, and let the potential client know you can hire an attorney for that. It sounds like nobody else wants to revisit the counterclaims issue, so maybe explain what a counterclaim is, and in federal and state court, and potentially what remedies would be there. And then it sounded like we were saying, no attorney's fees unless there's a law change, and then the turn, so that we're really explaining what it means when it hits the ground for a person who's the aggrieved person trying to collect the damages.
Steve, and then I have a comment. And my comment's really quick unless you wanna. Okay, here's my comment really quick is how, it's a question actually, how much space in terms of paragraph or sentence, Amos, what are you thinking in terms of if we drafted something, what would you want it to look like?
But isn't that form over substance? Shouldn't they really just get a really good disclosure as opposed to us worrying it's too long?
I think the regulation subcommittee is worried about the burden on paraprofessionals. So the idea would be as much as we could standardize it, as much as it could be form, as much as we could put it on a website and provide a link, that would be ideal. But it's got to be clear and understandable to consumers because the point is for them to be able to make an informed decision.
Okay, any other ideas to bring back to the regulation subcommittee?
I would just say that I'm happy to draft some things. I know they might get too long, and they might even be counterproductive, but I'm happy to try and figure out the big things. I'm happy to try and take a crack at that. I might be able to give you 2 or 3 versions, some of which you will not approve. You will not like, it should be too long. But if that would be helpful.
So I think it would be helpful. I mean, I do think simple is better because it needs to be something that, disclose. People have different views about how helpful disclosures are, but the more simple and straightforward and easy to understand, the better. But the concern I have is that if there's no disclosure, then it's just something that, people might not understand that when they're hiring a paraprofessional. And I think the high level ones that we've identified here are probably things that need to be disclosed.
Yeah.
Julia?
I was just gonna say, I think this is going to take some time and some thought. I really like that you came and brought this to us, Amos, but I think that all subject matter subcommittees should be told what Amos has told us so that people can start thinking about it before just, we're at the tail end of a meeting and what are we willing to do when we are already feeling tired and run down, and meeting out. I think it's really worth alerting all subject matter subcommittees that if they want some very specific disclosures about their particular subject matter relative to the abilities or lack thereof of a paraprofessional, that they start thinking about this and that your subcommittee or the regulation subcommittee you don't anticipate them adopting that task. I think we needed some notice of this and it's going to take some thought.
Yeah, okay, and I think when we have the discussion at the meeting on the 25th, that's a good time to raise it. We do have some places to start for most of the practice areas, just like there were some bullets Amos had prepared. I added the one about turn. There's some things in housing, for example, the fact that you may be in a county that has a right to counsel for housing. So there's some that I think we do have and can self-generate. But I think at the meeting on the 25th, Amos can raise this as a need for all practice area specific subcommittees and we can give that assignment. Okay.
Leah, I have an unrelated question for you.
Okay.
The legislature is rattling its saber about state bar funding again, and I'm hoping that gets worked out. If it doesn't get worked out, how is that going to impact our working group's timetable, if at all?
I don't think it would. I mean, I think it impacts the timetable only in the sense of what is the atmosphere like in the legislature right now for the state bar, but not in any other practical way, because that's with respect to the fee bill that goes into effect January 1 of 2022. And this timeline that we're on is for the next cycle, January 1, 2023, which hasn't even begun. So.
Okay, but it's not, okay, so it's not like the federal government, where the federal government, if they don't reach a budget resolution, the federal government gets shut down. The state bar is not going to get shut down. Our working group is going to continue to meet, et cetera.
Yeah.
Okay.
Julia? You're on mute.
Sorry, I meant to have my hand down. I've already spoken. Thank you.
Okay.
I had a question for Amos on housing. Amos, on housing, did we ever take into consideration limited versus unlimited jurisdiction? And is it too late to do that?
So I have raised the issue that I think one of the public commenters raised, that the housing resolution that was passed may have unintentionally been too broad, including not only unlimited, but affirmative litigation. That was never considered by the subcommittee. So the housing subcommittee is not meeting. I was told that should just be raised separately, but it might be that we need to revisit the resolutions if they might have been unintentionally overbroad.
I would certainly be in favor of limiting it to limited jurisdiction for a lot of reasons. But let me also add, while I think historically most unlawful detainer action $25,000, post-COVID, where you've had eviction moratoriums for over a year, I can see that not being the case. So I think we need to limit it to limited jurisdiction. And I think that may not be just a hypothetical problem in the future. The other limitation I'd have to give some thought about, but I wanted to pass that on to you.
So I had a similar reaction. So I think maybe the answer is to just raise that with the chair of that subcommittee, and it sounds like we might want to have it.
Well, don't we have a meeting later this week where we're voting on some housing proposals?
Yeah, it's a full working group meeting.
Yeah, that's what I mean.
Oh, this.
But isn't housing on the agenda?
No, I think we're just doing family law. Or is housing on the agenda, Linda?
Yeah, it is.
Oh, it is. It's
The only housing issue that's on the agenda is lien clearing. The working group voted on the landlord tenant already.
Yeah. Are you familiar with this issue that's being discussed, Linda, that there was an unintentional overbroad resolution? Because I don't remember ever thinking that unlimited jurisdiction was included.
No.
Yeah, so I emailed.
Yeah, why don't you let us it sounds like we need to circle back with the housing subcommittee, but we won't be able to take it up this week because it wasn't noticed as such.
Right. So I did email, sorry if I forget now if it was Linda or Leah or both of you.
No, I know, I meant to, yeah, I don't think I got an email on it, but anyway, I think obviously we need to follow up on it. So we'll figure out how to do that. Anything else? Okay. Good job. So I'll write up a draft memo, very brief, for submission this is scheduled to go back to the working group June 25th.
Can I just say thank you? Before I used to feel like our meetings were a little tight and running out of time, but it's nice that you're setting them for bigger blocks of time. We can just really talk, and then we finished a little early and it's working out really well, I think. Thank you for doing that.
Sure. Yeah, thank Carol.
Amos, I'll be sending regulation another memo on the rules. I'll try to get it done tonight. Do you guys read what I send?
Yeah, the night before though. Steve, do you take any special vitamins that you can give us advice about?
My family says I never remember anything because my brain is filled with all this useless law stuff.
Well, my husband says I don't forget anything.
My husband forgets everything, so he thinks I remember everything, but I don't.
All right.
Okay, thanks everyone.
Okay.
Bye.
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 Bye. Thank you.